Hello, this is Attorney Mike Griffin coming to you from Chicago. As usual, I got a whole bunch of stuff. I have people to thank. Alyssa, Marion Harmon, Mikkel, and Katie M. Also an undisclosed source. I've got a bunch of clips, but the leader of the pack today is this knucklehead. I did a video on him yesterday. He got bench slapped beautifully by a magistrate. It was beautiful. I can't remember what I called it already. It was yesterday. Whatever. It doesn't matter. Stuff's it. He tries his stuff. It doesn't work. And then he's in Washington County. That particular case got set over in front of Judge Washington. That's not going to go well for him either. But in the interim, a date that I wasn't aware of. It's already all over the internet. He shows up in front of Judge Simpson today. And tries his luck with getting on Judge Simpson's nerves. It goes about the way you'd think it would go. It's so fantastic. But in there, I also have other clips. I've got a brief Chille update. I've got an update on Mr. Meeks. Who is Mr. Meeks, you ask? Well, I'll tell you who Mr. Meeks is. Mr. Meeks is the unfortunate soul who had this for an attorney.
Any objection? All objections.
Oh, yes. His case is carrying on. It appears he's representing himself, or at least the brief snippet that I have. It's only him talking, and he is horrible. He is absolutely terrible at it, but better than his prior attorney. That's what we're dealing with. All right, we got lots to get to. Let's do this thing, shall we?
Case People versus Thomas Styren. Here we go.
Public Defender of Otello on behalf of Mr. Styren, who's going to my left. Well, let's talk to the judge about that. Right? We've been through this. Seems to be some confusion.
What's the confusion?
I've stated multiple times on the record that I wish to represent myself.
Well, I thought we got rid of that issue the last.
Yeah, I thought so too. I spoke to this gentleman right here and expressed my wish to represent myself as well.
All right. Well, if he doesn't want you, I mean, we'll figure that out in a moment. So, Mr. Styren, we're going to go through this again. What do we want to do in this case? You understand what you're charged with, sir?
So, I understand what the charges are against me, yeah.
Okay, look, you're going to have to give me straightforward answers to my questions because I've got to make sure that you understand certain things. I got to do certain things here.
From my understanding,
you understand, first of all, that if you do indeed direct, you want to smile about it and laugh about it, take him back. We'll call him out later. Take it back. You keep laughing. You laugh one more time, that's 30 days. Go contempt. Look it up.
All right. 48 District Court for County of Washington, State of Michigan is now contested. The Honorable Judge Simpson preside.
You may be seated. Yeah, let's try.
I gotta talk more.
Try this again. Three calls case, People of the State of Michigan versus Thomas Styren II. Styren, you are before the court on a felony complaint that does allege count one, but I'm going to presume, since you do not want to answer the court's questions, that you understand English and understand what I'm saying. You are before the court on three charges. Count one is the charge of fleeing and eluding third degree. Under the Michigan Motor Vehicle Code, that is a felony punishable by up to 5 years incarceration or $1,000 fine plus court cost, and would require the Secretary of State to suspend your license for up to 1 year upon conviction. Count two is assaulting, resisting, and obstructing a police officer. That is a felony or high court misdemeanor punishable by up to 2 years incarceration and or a $2,000 fine plus court cost. Count 3 is a misdemeanor offense of operating with a license suspended, denied, and/or revoked. That is a misdemeanor as indicated, punishable by up to 93 days, $500 fine plus court costs. Your vehicle could be subject to immobilization. Since you refused previously to answer my acknowledgement as to whether you understand that, I will assume that you understand what you're charged with. You are also entitled to be represented by counsel at this and all subsequent proceedings. If you cannot afford to hire an attorney would be provided at public expense to represent you in this matter. You are entitled, as indicated, to be represented at this proceeding, all subsequent proceedings, including your preliminary examination, and if the matter were to proceed by trial, you would be entitled to counsel. It is, as we have gone through with the previous proceedings, the court's understanding that you do not wish to be represented by counsel, and that this matter will then proceed forth with you representing yourself. I have to advise you that in representing yourself, the court will make the presumption that you understand the Michigan court rules, those regarding both procedure and those regarding evidence. The court will not be providing any legal assistance to you during the course of those proceedings and will hold you to the same standards that I would hold an attorney representing or practicing before this court. So, with all of that, and with the court's understanding that you do not want to be represented by counsel, I will set this matter for its next proceeding.
You understand I'm the beneficiary, not the trustee, right?
That will be the preliminary examination. I will set the preliminary examination. Has discovery been provided to the defendant?
Your Honor, he was previously represented by the public defender. I don't know if they turned over the paperwork to him.
Does anybody from the public defender's office know whether or not the defendant has been provided discovery? Mr. Odetella. Thank you, sir.
Thank you. Your Honor, we have the discovery. I have not been able to share that discovery with Mr. Styren. I tried to speak with him and go over it, but I'd be happy to turn that over to him at first available.
All right. If you would either turn that over to the court officer so that they can provide that to Mr. Styren so that he has some discovery. And if you could do that today, I would appreciate it.
Yes, Your Honor.
Setting the preliminary examination. Thank you, sir.
Yes.
The people would have their witnesses available June 11th. Set this matter for preliminary examination.
Don't worry. For those of you who haven't seen this yet, it gets worse.
In person, June 11th, 2024, 9 a.m. That is before me. Defendant, as was leaving the courtroom the last time, the court did find the defendant in contempt, sentenced him to 30 days. The defendant will serve that sentence. The court will sign the judgment of sentence regarding the contempt.
I don't understand how that's possible. Like I said, I'm
So
the
first of
man,
all,
I'm the
watch your
beneficiary. You're
language.
treating me as if I'm the trustee, or I don't want to partake in any trust fraud or anything like that. Is this a Section 2A trust matter involved in this? Is my Social Security number attached to this at all? Go figure.
Styren, or whoever you wish to be addressed as, I'd suggest that you watch yourself because there's going to be more time coming. You keep it up. You will learn how to conduct yourself appropriately in these proceedings in this courtroom and before me. You will not in any manner whatsoever
You're trying to compel me to be somebody I'm not.
or this institution.
You have no evidence
It will not
to prove that
happen.
I'm who you say I am.
You will not talk to me in that fashion.
In what fashion? I'm not the one being unethical.
Very good. You'll serve the 30 days. We'll see. We'll see him on the 6th. Bond continued.
He earned a full fez salute there.
Who wants to go next?
Do I have at least 2 witnesses that they are committing treason? This is treason. They're violating my rights.
All right, in jail there, your name, please.
Trudy Marie Coon.
Ms. Coon, this is felony file 242140FY. I'm going to read it to you.
Trespasser on behalf of Ms. Coon for the purpose of arraignment. We have reviewed the charging document and waive a form of reading. We did conduct a screen for indigency and found she does qualify, so she will be having a court-appointed attorney. We request this matter reset for probable cause and preliminary exam.
Okay, so ma'am, you do have the public defender as your attorney in this
Oh, you guys are going to hate this.
matter. You wish to argue for bond?
Yes, Ms. Coon was previously bonded on the same charge. It looks like they amended the complaint and then reissued these charges. Before the original one, I did represent her. She had no issues attending court. She takes care of herself and her mother, who is in the hospital right now, which has been, throughout this court case in the past, one of her other priorities on top of, and with that, she still was able to attend all of her court dates. So we ask that be taken into consideration and a PR bond be granted again. Thank you.
Okay, but ma'am, you're already now on bond, out on bond for a felony meth that occurred in February, right? So you caught
Yes,
this
sir,
while
but-
you were on bond already?
Yes, sir.
All right.
But,
So it's gonna be, ma'am, your bond's gonna be,
This poor judge just gets abused. I keep having him on here. It's Norbert or something. Everyone told me last time. He is a nice guy. He's always nice. But his call, man, do they just dump on him?
$2,000 cash or surety, no drugs, no alcohol, no marijuana.
I know that. Please, honor. I don't have no money.
Ma'am,
Nobody has any money.
you picked up a new felony while you were out
I
on
know,
bond
I
for a
know.
pending felony.
I know, but my
and
mom's
there's
in the
different
hospital.
kinds of felonies, so we're all set. You already have
Please,
next court
honor. You,
dates.
please, I beg you.
You
I
have
beg
a
you, Your Honor,
probable
please.
cause
Can I
conference
get a-
on May
can I-
30th. You have a preliminary
Can I
hearing on
please get a
June
PR
5th.
bond?
That's in courtroom A in front of Judge
Your Honor,
Scott.
please.
Man, you shouldn't even have gotten a PR bond on your first.
I didn't mean to. I thought it was taken care of because on Monday I thought it was taken care of. I didn't know. I didn't know. Please, Your Honor, I
Ma'am,
did not know.
Are you on probation from your felony in 2021?
No,
Yeah, you're welcome. You're welcome.
I'm not on probation yet. No, I'm not on probation. I ain't even finished with that court yet. I don't go to the court for that until July 3rd. Please, I beg you, Your Honor, I need to get out so I can get the house straight up
You're
before
all
my
set.
mom comes home.
We're done.
Please, nobody has, Your Honor. Please, can I, please, beg you.
Ma'am,
You
your
don't-
bond
nobody
should
has
be
the way
higher
to
than I
help
just
me.
said it. If you keep talking, I'm gonna set your bond higher. 2,000 cash surety when you're already out on a felony bond where we gave you a chance to behave and you picked up a new felony. That
But
is
I
no
didn't
way
know it was
in
a
shape or
felony.
form
I
a
didn't
PR
know.
bond. You're all
I
set.
didn't know it was a felony.
Okay, let's come over here so the next person can vote.
You know it's a felony. I said it's a felony.
Good afternoon, your name?
James G.
It means that you're not gonna get out, let's somebody, buddy, right?
It looks like you have two files here, a misdemeanor and a felony. We'll do
Mateus, Jared Regier for the state. Is Mary Mateus here?
Yes.
Miss Mateus, you are here on one count of speeding 97 and a 65.
Oh, this is some classic Jay Regier here. You're gonna love it.
That is a traffic infraction, so it does not carry jail time, but it does have a scheduled fine and court costs. Are you wanting a trial on this case?
No, I plead guilty.
All right. Is anyone making you enter this plea of guilty by any kind of threat or promise?
No.
And you understand that with guilty, you're giving up your right to a trial. You'll be found guilty and unable to appeal your conviction.
Yes.
So do you admit that you were speeding at 97 in a 65 mile per hour zone in Butler County, Kansas?
Yes.
And do you remember when you did that?
April, I forgot the exact date.
About March 4th, maybe, 2024?
Oh, yeah.
Okay. And I don't see a copy of the ticket. You were where when the officer stopped you?
I was on 400, like a little past Andover,
East of Andover or west?
east.
Okay. I will accept your plea and find you guilty. And Mr. Regier, do you have the fine there by chance?
Your Honor, may I respectfully inquire as to the case number? I do not appear to have this case on my docket either.
All right, it is 2024 TR 656.
Oh, Regier, just what's the case number? May I respectfully request the It gets worse.
Your Honor, the state would respectfully inquire as to a copy of the ticket. In this particular matter, absent that, I do not believe I am in a position to make appropriate recommendations. So I'm not sure if the court wants to set this over or not at this time.
Do you know where the ticket is? I assume it's KHP since we don't have it in its normal file, Destiny.
Yes, Judge, it is a KHP ticket, and I believe that is one of those that we may not have access to because of when things were switched over from Smart Cop.
All right, so what are we going to need to do? I thought we could come up with that and Mr. Regier would have it, and we don't. I'm going by what Odyssey has recorded, but we really do need to see the charging document. If Mr. Regier doesn't have it to offer to me, then I don't want to set this over, but I may have to. Any suggestions from the clerk?
I'm unsure, Judge. I know we don't have access to a certain amount of tickets from a particular date span at all. We can't get them back.
Ever?
No, we've tried.
Well, then I'm inclined to dismiss this case if we can't ever get copies of the tickets. Mr. Regier?
Your Honor, under these particular circumstances, the state would be requesting that this matter be set over while reserving issues concerning the final outcome of this case at the next hearing if the court is inclined to grant such a continuance.
All right, Ms. Mateus, what I'm going to do is set this over one time.
Okay.
And if they don't have the tickets, I'm going to dismiss this.
Regier's not going to let this go, which is admirable. That's his job. He's supposed to hold the line, but he is not going to let this go. 99 out of 100 prosecutors would be like, yeah, whatever. Okay, fine. If we lost the ticket, I don't care. I'm not going to chase the speeder around.
We've had some strange things going on with the state computer systems, and we've had some changes. But I think that's the way we're going to proceed. So, Destiny, when do you want her to come back?
Judge, I can set over. How far out are you wanting? Are you wanting it sooner rather than later?
Well, Mr. Regier, how much time do you want to kind of try to see if those tickets can ever be recovered?
Your Honor, at the very least, the state would be requesting a continuance of 30 days.
30 days? Okay. 30 days it is. What will that be, Destiny?
The earliest I can do, Judge, is August 7th.
Okay. So, Ms. Mateus, you can either be back here August 7 at 9, or you can call the clerk and see if your ticket's been dismissed by then.
It won't be.
Okay. And if
Not with Regier around, it won't be.
if it is dismissed by then, does that mean anything for fines? Do I still have to pay them?
No.
No? Okay.
Now, it might be possible that they could, even if he doesn't have a ticket, they could file that on information, but I doubt if they'll do that. So, in any event,
Okay, I won't bore you with too much of this, but yes, the alternative is for a speeding ticket, the charging instrument is the ticket itself per se. But you know, most crimes, if they're a little more complex, you charge them with an information. So you write it up and you file it. It's sort of like a complaint. It's the initial thing from the state. So I mean, his alternative is he could just file an information on it, and I think he will. I think he'll do it.
We will see you back here at that date and time unless you're told otherwise when you call the clerk.
Okay.
All right, thank you. We'll be in recess.
And Your Honor,
Yes,
for purposes of the record, is the court finding that a plea has been entered one way or another in this matter at this time?
I'm finding that a plea has been entered, but I'm going to take no further action until I get the actual charging document.
Very good, Your Honor.
Thank you.
Page 16, State versus DeCastro versus State Nevada, C381.
Okay, this was passed along to me in Discord. It isn't very interesting. It's just, it's short. It isn't very interesting. Just the best part of this is a reminder that Chille's still in jail. While his attorney is fighting the good fight for him, he's still in jail.
730. Well, you already filed this brief.
Yes, all I was doing was motioning. When I do it in the Supreme Court and I go over the 30 pages, we have to file a contemporaneous request saying, could we have excess page number? So I did that.
What if they say no? Did it strike the last 10 pages?
This guy seems to be a good attorney, but I will tell you this right now from years of practice. There's nothing judges like less. From appellate court judges to regular judges, whatever, is exceeding the page limits. They literally hate you from the get if you exceed the page limits.
I'm going to grant it.
But in Margaret Rudin, they actually said no. And I remember I had to cut back some. So yes, but that's the only time. And it was 120 pages. Just lower the bar.
How many did they allow you in that case?
I don't recall.
Jeez. Okay.
I don't recall, but it.
I'm assuming the state has no opposition.
No, I have no.
Okay, so it's granted, and the only thing that motion to admit, that stuff was all presented at the trial level, right?
No, part of it was, and I don't think the state has an objection to that part. I was concerned because the Supreme Court on Appeal said we have to make sure that the higher court, their court receives everything that was utilized below. So there was a video, body cam video from the officer that the state admitted. I did not know how to generate it so that this court would have it. And I was concerned the state could possibly say that I didn't do anything to get the evidence before the court. So I just motioned the court to say, hey, could we please make sure that that's included? I don't think the state has an objection as to the dash cam.
Anything he uses that was presented at trial, I have no objection to. Obviously, the other exhibits that he puts in, that was not anything that was presented at trial. We would have an objection to those exhibits.
And there were some that I have just included. So when the court asked me that, yes, there are exhibits that were not included in trial, they're not mentioned in trial. And so I am saying, could the court consider that? And so I think maybe
You weren't at the trial level. You
you
weren't the attorney.
No. And we are raising ineffective assistance of counsel as well. So that would permit me to go outside of the record. I may be filing something because he is in custody, a separate writ. The issue was already raised, but I may just raise it as a writ so that I can then explore issues outside of the record. But I know that Mr. Chen objects to the exhibits that were not admitted, and there were a few that I requested.
You're going to ask the court to consider.
Yes.
So it's a direct appeal and I guess post-conviction?
Yes.
Mr. Chen?
I don't know if procedurally it was absolutely correct, but at the end of the day, I'm allowing Mr. Orm to file what he wants to file in this appeal. So whether it's the direct appeal and treating it as a petition, if the court wants to construe it as a petition, that's totally fine with the state. We'll just...
Translation, their argument sucks so bad I don't care. Let him do whatever he likes.
And that probably will save some trees, because I was going to, having heard some of the state's concerns, I thought about filing a separate writ, but if we can, I may refile it just with the form, because I'm concerned that on appeal, the Supreme Court, if there was an appeal, the Supreme Court could say this wasn't properly preserved. So I may do that, but it wouldn't slow anything down because I'm not going to raise anything that has not been raised already.
Okay, so it's granted. We'll clear the order on these. And I think July 10th, right? I think we're here. Everyone's on track to meet that date.
Yes, sure. Yeah. Okay, thank you very much.
Yeah, thank you. Have a good day.
Yep, still in jail. All right. Also, a big shout out to our Nevada judges. I didn't even think about that. Obviously, that was brought to us by them, Alex and the fine folks at our Nevada judges, for all your Nevada litigation needs. All right. I have a late entrance here. I have to hunt it down here. I'll just take a second.
Any objection? All objections.
Oh yes, this is Mr. Meeks. Mr. Meeks is a kook, as far as I can tell. He was making no sense in the hearing. That's a classic. I don't know. I'll find the link. Somebody help me. I'll find the link to. I often get asked where that clip comes from anyway. But he was a kook throughout that hearing. However, he was overshadowed by his even kookier attorney, who I just played the clip of. So there we go. Now here he is, Curtis Meeks, unplugged, pro se, as far as I can tell, laying it down in court. Like I said, it's bad, but it's still not as bad as when his attorney was doing it. Let's do this, shall we?
The opportunity to do so, which means, Mr. Meek, I need you to raise your right hand and unmute yourself, sir. Mr. Meeks, do you solemnly swear or affirm under penalty of perjury that the testimony that you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. Earlier, sir, there was something you wanted to tell me.
Oh, yes.
And I'm not sure, but I think this is the same case as the one with the all objections attorney. It's some real estate transaction that went sideways. As you hear him talk, you'll see how everything in this life must go sideways.
But before I get started, can I go ahead and talk without getting interrupted, or I got to get interrupted when I'm talking? Like, I want to talk and get my point across. Like, I let Coon talk and everybody talk. So I want to talk and do.
Yeah. Just a second, Mr. Meeks.
Do the same. If it's cool. If not, I don't even want to talk.
So objections could be made at any time. That's what, lawyers typically make objections.
Okay.
If they do make an objection, I need to be able to hear that objection.
Okay.
But there was something pressing that seemed like you wanted to tell me, which caused you to interrupt the proceedings earlier. And I promised you I would give you the opportunity to tell me what that was.
Right. And that's why I want to go ahead and talk without being interrupted. But I'll go ahead and take the floor. Well, first of all, we ain't heard nothing about no lien of the $250,000. We not heard nothing about that at all. That Brenda Walton that I've never seen in the last 4 years. She haven't been in court at all. I just hear Walton, like I don't know her. So she put a $250,000 lien on there. We're not hearing nothing about the lien of $250,000. This is what this case is about. Kuma is doing something and trying to tell Alan to do, like, don't get a lawyer and then I can do a default and then Miss Brenda wins the whole house and they take everything and all that, which that ain't gonna be the case. But anyway, what I was saying with Paul Morin, he had a stroke. He forget a lot of things. I've been working with him for the last month. I help him pick him up and put him in the car and help him. We got take him go get something to eat. And he kind of messed up a little bit, but this is my lawyer and I'm gonna take care of him. I'm gonna help him as much as I can. But well, with this $250,000 lien, I don't hear that nowhere in here. We're talking about a lien that's on this property that she put on there from Park Place Funding. Park Place Funding was going to foreclose on AACSI that I didn't have nothing, like I didn't even know nothing about. So I said, hold on, Alan, do y'all have the money to pay Park Place Funding? They said no. Okay, well, I step in and pay Park Place Funding with my hard-earned working money and got the agreement from Alan to sign. And we go up here and I pay the Park Place Funding off. Now Miss Brenda puts the loan on there. I mean, the lien on there for $250,000. That nobody's talking about the lien. This is what we're talking about, a lien of $250,000. Now, if a lien is for 250,000, I say, okay, Your Honor. Well, I was talking to the last judge. I said, I got $250,000 cash right here that I will put into the registry of the court, because this is what she's saying that she put a lien on my property for. So I will go ahead and give her the 250, put in the registry of the courts, and we'll fight and keep going over the years. They said, no, they don't want to do that. Well, what is y'all trying to do if we can't do none of this? I mean, because we're here to talk about a lien for 250,000. Y'all, I done got over $1 million in this property. First, they got the loan for $595. They gave Miss Brenda $220,000 because we bought it from her. Now I had to go in my pocket and spend additional 200-some thousand to finish building it, plus the 600-some thousand that I paid Park Place funding off. So she put a lien on here for 250,000, and Kuma is convincing Allen not to get represented by attorney because counsel. So I had to foreclose on AACSI with the agreement and all the paperwork that we had. I foreclosed on the property, and it wipes the lien out, and then Coomer said that was a fraudulent transfer. We had to do a TRO and this, that, and how's anything fraudulently? And I'm spending my money. But we're not going to say nothing about none of that. We're just going to say, okay, well, just the default, and we just take it from Curtis, and that'll be that. And that ain't going to happen. So I would like to go ahead and let Coomer know, let's talk about
Hell no.
and quit trying to talk about sanctions and default. Allen didn't agree. He didn't sign. Well, they tricked Paul. They tricked Paul Moore, and they slipped that paper in there because they know his illness. They slipped the paper in there where he didn't.
I'm sorry,
read
sir. I'm sorry to interrupt. They slipped it in there, and I didn't hear a word you said.
Right. They slipped the paper in there where they have it weighed at the bottom, and Paul, they know Paul wasn't going to read all of it. And it's saying if we only doing it for the default. But Allen signed for AACSI like he was acting like he was signing for AACSI to get represented. Because he know once a lawyer get on this and get represented, that this case is going to be all dismissed.
Any objection? All objections.
So he's trying to keep up the BS with everybody and keep it in courts and all this. And it ain't no, well, Curtis going to give up and he's going to do this, that, and the third. And I'm not. I want to know if this lien is correct. And if she's owed 250, I want to pay her. You know what I'm saying? But they don't want to get to that. They want to go get their charges. They don't want to get to none of that. You know what I'm saying? They just want to keep talking about sanctions, default. Allen didn't sign for representing AACSI. For my understanding, I didn't sign for AACSI to get the loan for Park Place funding. Allen got the loan for AACSI. I didn't sign anything. I didn't sign a venture agreement with Miss Brenda. He signed that. I didn't sign none of that. But they're going to go back and keep.
Don't worry. This gets both worse and weirder.
Saying, well, both parties got to sign. Okay, why both parties didn't sign on all the other stuff? It's just a lot of BS, and I'm trying to get to the bottom of it, and it seems like I can't get nobody to get to the bottom of it.
It's just a lot of BS. He could have just said that and called it good. You know, like you disagree with it. All objections next.
I done seen judges get new attorneys. Every time attorney they asking for money, they don't want to. I'm steady paying my money, like get another attorney, and then they want to withdraw. Like, are we gonna ever talk about the lien for the 250,000, or we not going to talk about it? That's what but I don't understand it.
I don't think he realizes that if you're claiming that you're paying the attorneys, but they're all withdrawing, that means that the position you're taking is probably wrong and or unethical. That's the only thing that explains that scenario.
This rule that you got to abide by, and I've been trying to do it, but it looked like we ain't going to ever get to that point. Because he's saying Allen not signing on AACSI behalf. But my understanding is if Curtis Meeks loaned AACSI the money and I foreclose on him because
I love the referring to Curtis Meeks in the third person. That's beautiful.
Because AACSI didn't pay Curtis back, what seems to be the problem? But I'm gonna let the judge and let y'all take it from here. And if Coomer got anything to let Paul know, he can talk to Paul, and I'm done from right there, Your Honor.
Yeah, you're gonna let the judge decide this issue as if you have a choice. That's cute.
Okay, I'd like to object as non-relevant to today's hearing.
But we know you like to do that, Coon, man. That's understandable. But listen,
All right.
Your smile make my little life worthwhile.
Well, I don't know what that was, but it is the last day of school. And so a lot of things are happening today.
Can I speak, Your Honor?
Give me a moment because I want to explain something to Mr. Meeks. And what was that? Was that somebody's computer?
no, that was for Coomer. That's what he liked to hear that song like every time he come in. He
Oh my
likes.
goodness. Okay, let's not do that.
No, it just popped up on the computer. I tried to turn it off. That was on accident.
All right.
Well, there you have it. I don't know. That stream was all over the place. I had updates on everything. We had updates on Chille. We had, of course, we kicked it off with the knucklehead soft sit, who thought it was a good idea to go and press Judge Simpson's buttons. Who here thinks it's a good idea to press Judge Simpson's buttons? I don't. I wouldn't recommend it to anybody. Honestly, we kick it off with that. Then we've got Super Whiner. What else do we have in there? We have Jay Regier. He wants his $2. He's not going to let it go. He's not going to let it go. Hell no. Then we've got Chille still crying in jail and an update on Meeks. That right there is 5-star prime streaming right there. You can't beat that anywhere. Thank y'all for coming out. I appreciate it.